All right, good afternoon, everyone. I think people are still joining, so I'll give it a second. But in the meantime, I'd like to introduce myself. My name is Gary Tokumori. I'm an attorney at Parker Milliken and also chair of the Remedies section of the LA County Bar Association. I'd like to welcome all of you to our program today. What writs and receivers judges can tell us about prejudgment remedies in COVID-19 times. We'll go ahead and address what's new at the courthouse and some best practices related to prejudgment remedies. And we'll also have a brief discussion of some very recent changes at the court related to post-judgment matters. We've tried to design this program to cover issues of general interest to all practitioners and also address both common and more detailed questions. We hope to have something for everyone attending today, whether you're someone who frequently visits the 8th floor at Stanley Moss Courthouse, or whether you're someone newer to the prejudgment remedies part of our practice. Before we get started, I wanted to provide a couple of general resources. The LA Superior Court website does provide information related to how it's addressing and handling COVID-19 issues. And specifically, when you go to the site, you'll see that the court has taken the Here For You, Safe For You initiative forward to deal with how the COVID-19 has impacted the courts and what we can do collectively in the legal community to prevent any further issues and to use best practices in terms of safety for everyone. The other thing I'd like to point out is for those of you new to the practice area and just as a refresher to more seasoned veterans, local rules 2.8 and 2.9 address the matters that are heard by the Writs and Receivers Department and also how those matters are assigned out. Finally, we are going to take questions. We'll probably take them at the very end. If you would like to submit questions, and I can't guarantee that we'll get to all of them, but I'll ask that you send them to me via the chat feature directly and only to me if possible. It'll be easier for me to sift through those at the very end. So now, without further delay, it is my privilege to introduce to you our panelists from the Writs and Receivers Departments in the Stanley Moss Courthouse. We have the Honorable Mitchell Beckloff from Department 86. Welcome.
Thank you for having me.
We have the Honorable James Chalfant from Department 85. Welcome, Your Honor.
Good afternoon.
And we also have the Honorable Mary Strobel from Department 82.
Hello.
Good afternoon, Your Honor. All right, thank you all for agreeing to join us for this program. You know, I don't know where to start. These are definitely the most unusual times I've encountered in my years of practice. I'm sure I'm not going out on a limb to say that's the same for all of you as well. You know, the phrase unprecedented times seems to apply here. We've seen a court closure for somewhere in the neighborhood of 3 months now. I'm not aware of that having happened in the past, and also having to deal with the COVID-19 issues that makes going forward a bit difficult. So that being said, why don't we get started with some general safety issues and concerns and initiatives taken by the court related to COVID-19. Generally speaking, what are the biggest changes in how your courtrooms will operate when the courts reopen next week?
Well, the biggest change is that we are encouraging everyone to appear remotely. Want to discourage foot traffic in the courthouse to the greatest extent we can until things change. So that will mean appearing by court call or when our Court Connect is up and operating, which should be which is scheduled to be July 20th, you can appear on Court Connect, which can be either audio or audio plus video. So that's the biggest thing, is to avoid coming to the courthouse if at all possible. If you do come, there's some other things that you will observe that maybe Judge Beckloff or Judge Chalfant wants to speak to.
Sure. Let me chime in here. I think one of the important things to recognize is that in order to keep the courthouse open, we're going to have to manage with social distancing. And I think you'll see when you come to court a lot of changes. For example, in my courtroom in Department 86, there are 107 seats for members of the public, attorneys, whomever, to sit in the courtroom. Under the court's social distancing, I now have 13 seats for the public. So if you think about a heavy calendar in any of our writs and receivers departments, there's absolutely no way the court can accommodate and all of the attorneys showing up for calendar when I, for example, have 13 seats. And if we can't get to the point where attorneys and parties are used to appearing remotely, either through Court Connect starting in July and by court call, then we may suffer being shut down again, which I don't think anybody wants. But that's the most important thing. If we cannot manage the crowds and the people coming into court, then we may have to be shut down again. So we can recalculate how to do this.
Let me address the remedies lawyers, who I think the kinds of matters that you would bring before us, writs of attachment or right to attach orders, writs of possession, receivership, remedies. I cannot, well, I mean, yeah, it's possible, but let me back up. We can't prevent you from coming to court if you want to make a personal appearance. But as Judge Beckloff said, if traffic gets too heavy, we're going to shut the court down again, which nobody wants. So in your field, I don't believe it would be an extremely rare case where you should not appear by court call. That is, all of your matters are matters that we handle on a regular basis. All three of us are very familiar with injunctions, attachments, receiverships, and writs of possession. We know what the law is. We look for the facts. The matters are often, usually straightforward and sometimes unopposed. These are matters where you should not be coming to court. You should not be afraid, and you should tell your clients that the judges don't want you to come to court on these matters, and you shouldn't be afraid to appear by court call. I really don't think these are the kind of matters where you or your client should insist that you appear.
One of the
that includes both ex partes and noticed matters. We want you to appear by court call on ex partes.
One thing I was going to add is, I don't know what Judge Chalfant and Judge Beckloff's practice will be, but for at least the next few weeks, my clerk is contacting parties to ascertain whether they're intending to appear remotely, and if they are intending to come to court, we may have to adjust the schedule for that hearing. So you may expect a phone call on that.
Okay, appreciate that overview. Let me just ask a few follow-up questions on some of the things that were mentioned. Judge Strobel, you mentioned LA Court Connect, I believe is going or scheduled to go live July 20 for the Stanley Moss Courthouse. And my understanding, and correct me if I'm wrong, but until then, court call will still be available, and as I understand it from all of you, the preferred method of appearance, is that right?
That's right. Court call will be available until Court Connect is up and running. But once Court Connect is up and running, we will no longer be using court call. And just a side issue, the charge for using Court Connect is going to be less expensive. I think it is scheduled to be about $15 for an audio and $23 for a video, which is, as I understand it, is less than a court call.
One collateral point on this, all three of us have discussed hearing all court call matters in chambers. In other words, we'll just jump on court call or court connect and hear it in chambers. My reasoning is we are required to wear masks in the courtroom, and I have already found it very difficult to hold a conversation with a mask on. In chambers, as right now, I'm not going to have a mask on, and so the proceeding, I think, will be much more lucid through court call or court connect.
May I add to that the talking or speaking through a mask, I think, is going to be very difficult to decipher for the court reporter. So you've got that issue of the court reporter trying to understand the parties as well. And to me, the beauty of either court call or court connect when it's up and running is whether it's by video or audio, if everybody's appearing through court connect or court call, there's no reason for the hearing officer to be out in the courtroom. The court reporter can be out in the courtroom and hear clearly over the, and as I understand it, the court reporter's going to have access to the monitor or the ability to see the monitor if it's video. So I think it's going to make for a much cleaner record. And I don't know, you know, we wear masks when we go to the store and when we're out in public, but it's quite a different, I noticed yesterday, just trying to have conversations with people, you know, after about 10 minutes, it becomes extremely uncomfortable. I'm adjusting the mask. It's hard to understand some of the people speaking to us. So I think there's a real beauty in the remote appearance. And I think it just requires all of us to recognize that it's sort of new. I mean, we have court call, but it's going to take some getting used to, but I don't think there's any reason to be afraid of the remote appearance.
Okay. One follow-up question to that is, I know LA Court Connect is going to offer both audio and video capabilities. Will you have a preference, one over the other, or are they equally the same to each of you?
I would prefer the video.
I think I agree with Judge Strobel. You know, one of the problems we've probably all seen in the courtroom on court call, none of the three of us have experienced Court Connect yet. So we don't know exactly how we will interact with it in terms of the way we do with court call. So we all know that in court call, when somebody's on the line and they're speaking, it's impossible for the bench officer to interrupt that person unless there's a pause and a breath is taken. And I think the beauty of the video is you've got nonverbal cues, and even if someone's speaking, you know, you've got your hands up to say, you know, to let someone know that there's a question. And if I'm questioning something that's being argued, you'll probably see it on my face. So I think probably for me, I agree with Judge Strobel, video is the best. And at $23 a call, you know, it's a bargain.
Great.
Yeah, I think it sounds like there's definitely a strong preference for video appearances, and I know we're looking forward to that capability on July 20 or thereabouts. Yeah, I agree. It does, I think, offer the opportunity for visual cues, which I think will make the process go much more smoothly. That being said, are there any instances in which you feel that live testimony would be beneficial?
Live testimony? I've been in Ritz for 13 years. The number of times I've taken live testimony has been twice. They were both contempt hearings where I'm required by law to have live testimony. I mean, we just don't do live testimony, at least I don't. So I don't know whether you mean live testimony or live argument. Live testimony, no.
Actually, Your Honor, it would be both, testimony and or argument.
Well, look, there were times when I was a lawyer where I certainly felt that I had to come to court to make my argument and stand on my feet and perhaps with my client present. And we can't stop you from doing that. All we can do is warn you that if it happens too much, we're going to have to take action. So you know, and in the remedies kind of matters, I just don't see a need to come to court. You know, even if I was a lawyer, I don't see a need to come to court.
I think for me, if I was having an argument and I felt that for some reason, I can't imagine what that would be, that the parties, the attorneys needed to come into court to argue, I would certainly continue the matter so that I could have the parties come in. I don't think that the quality of justice that's going to be dispensed is any different whether you're remote or in person. And I think that when you come down to the courthouse, you will probably be surprised at the number, you know, we have a lot of signs here, but you'll be surprised at all of the social distancing signs. So, you know, our elevators, which are notorious for not being that great, only 2 people at a time can go in those elevators. So if you've got to get up to the 8th floor, that's a long way to go. The benches in the hallway are now situated so only 1 person at a time can sit on the bench. So I didn't count the benches today, but there are maybe 10 or 15 benches. So there's only a seat for 15 people. So we can't have everybody show up to calendar and then go out and wait in the hallway until their matter is called, because we don't have the room in the hallway because we have very narrow halls. So it's for the system to continue operating in this state of COVID-19 and the new normal, it's just the way it's going to be. So going back to that original question, Gary, if I felt during a hearing that there was some reason I needed the parties to come in to argue, I certainly would continue it to have them come in and argue. And then that way we can make arrangements.
I agree with Judge Beckloff. I can't think of a scenario right now where I would ask the parties to appear, ask the lawyers to appear. And the important thing to me in a hearing is to be able to have a give and take. And we can do that on Court Call, and we can do that on Court Connect video eventually. So unless I asked otherwise, that the presumption should be that you appear remotely.
One other thing I might add, sorry to interrupt, is, you know, in the social distancing, I talked about having 13 seats in my courtroom for people to watch. There's only 2 places at counsel table to stand or to be seated. So a lot of times when counsel come to court, they've got other attorneys with them, helping them, whatever it is, but there's not a place at the table for them. So it probably would be a much more satisfying process if you have a team of lawyers to be at least on video, so that there's some participation there, or the ability to pass notes back and forth instead of stopping and going back and talking to somebody in the audience. I think it's just a whole new world down here.
Okay, that's definitely good to know. One question that we had is, in terms of your departments, are you, because of any restructuring or because of the COVID-19 issues, are your departments handling anything different than what you had been handling before the closure?
Turns out we're getting one additional, well, Department 44 is closed. And we thought until yesterday that we were going to be handling post-judgment receiverships. Turns out we're not. Those are going to go to the IC courts. So the only additional work we're handling from Department 44 is fee waivers for our own cases.
There is one other issue I might bring up, and that is because of the backlog, because of the court's limited functioning over the last 3 months, there's a backlog of criminal cases and there's a backlog of unlawful detainer matters. And so during the break, I, for example, participated in a number of criminal law continuing education classes taught through the judges. It may be that one or all of us or none of us get recruited to do criminal cases or UDs. So it's conceivable that and when you talk about extra additional work or different kinds of cases, one or all of us could be doing criminal cases or UDs. I think it's doubtful, but there's always that possibility.
Okay, you mentioned the fact that there's a backlog. We understand that only ex parte matters were being heard during the past 3 months during the closure of the court. Is it safe to say that there's a backlog in each of your departments at this point with regard to, for example, OSC hearings, matters that were on calendar that have now been continued. Is that a fair assumption?
Well, it may be different for the different departments. I will say I tried to continue matters that fell in the time we were closed for 3 months. I already had cases set on those dates. So don't be surprised if you had something set in August that you may get continued, because something that was earlier and got continued to that August date may take precedence. In terms of OSC, RAPI, we had continued those if they fell in that 3-month period for 21 days at a time, according to the Chief Justice's and Judge Brazil's order. Those will go. I have 3, 4 next week. So they'll be heard on, at least here, on whatever date they've now been set for, unless the parties, of course, work things out or stipulate to keeping the TRO in place and continuing them.
And my department's pretty consistent with Judge Strobel. So OSCs were just sort of on a rolling 21-day continuance until that 21-day continuance date landed outside of our emergency orders. So like Judge Strobel, I have a number of OSCs, RAPI, that have been continued a number of times during the emergency period, and those will be heard next week and the week after. And like Judge Strobel, I continued writ hearings no more than 90 days out, and there are some writ hearing dates where there might be 3 or 4 on calendar, which just is probably going to be problematic. So it may be that certain matters get continued further.
My department's a little different. We certainly the OSC RAPIs got rolled over, and I will be hearing those. Provisional remedies, I tried to keep up with by issuing tentatives during the 90-day period to the extent that I could, and I was able to dispose of a lot of those without hearing. So I'm pretty much up to date on notice motions. I think we're gonna, if you were to file today in my court for a right to attach order, it would be heard in August, so which is, 2-month delay.
And just a follow-up question to that, will you be having additional hearing dates and times during the week, or are you maintaining the same hearing schedule as you've had in the past?
Yeah, we can't do that. I mean, I initially contemplated telling lawyers, hey, if you want to bring your own court reporter, I could hear a matter on an off day, but that is inconsistent with the direction we've had to keep the courthouse as clear as possible from attorney and party traffic. So the short answer is no, we will not be hearing matters other than on our calendar, and our calendars are going to be restricted.
And one more follow-up on that. In terms of the calendars, will you be, for example, rather than an 8:30 calendar, I know some departments are scheduled to have different times or a staggered schedule, for example, an 8:30 hearing, a 9:30 and 10:30. Is that something that will be implemented in your departments?
Well, for me, if you're appearing remotely, which we hope you are, we'll keep the same times. If there are cases where people say they need to come in for whatever reason, it's possible that I would stagger those hearings, meaning not at 9:30, but at some other time.
One of the things that we've been tasked with is really mastering the number of people that we're seeing. So if there are a number of people that come to court that want to be heard, and we sort of know in advance, for example, my clerk is contacting parties about next week. If we know in advance that somebody wants to come down and we've got a number of people coming down, I think I'm obligated to stagger those. I'm not sure how we can socially distance in the courtrooms that we have with more than, for going back to the seats in my courtroom, 13 seats.
Same here. I mean, I've got my clerk calling to find out who's appearing by court call. I will be hearing the court call matters first. And when they are done, I'm anticipating that there will be at least some writ hearings, writ of mandamus hearings, where the attorneys are going to want to appear, and then those are going to probably be heard on a morning calendar at like 10:30 after all the court call matters.
One other thing I just wanted to mention is it's not just people coming onto our floor for proceedings in the writs departments. We also have a number of family law courtrooms on our little hallway, and some of those hearings require live testimony. So it's not just thinking about the people we're generating into the hallway, but how that fits in with all the other courts that are operating on our hallway.
Okay, it sounds like it's going to be a work in progress to ensure that we have social distancing, that we don't have too many people at the courthouse, and that we can get through this together. Let me jump into some of the more specific areas and questions that we've had. Let's start with temporary restraining orders. Just to cover some of the basics, I know that in speaking with all of you this week, we wanted to try to get out some best practices out there just in general for each of your departments. With regard to TROs and order to show causes, on TROs, if there's an ex parte and notice is given, do you consider ex parte notice by email sufficient in most matters?
Well, the general order says yes. That is an issue we used to worry about, but under the presiding judge's general order, which one I don't know because there've been so many of them, but email service is adequate for ex partes. Let me say one thing though. We want you to appear again by court call on ex partes, whether you're the moving party or the opposing party. We want you to appear by court call. And now the general order of the presiding judge says through July 9th, you may appear by court call on an ex parte. I'm assuming that will get extended, but I don't really know. But at least through July 9th, we really want you to appear on ex partes through court call. And the general order requires oppositions to be filed by 8 o'clock the night before, I believe, the ex parte appearance. So we will have both the moving papers and the opposition, and we can hear you on court call. But yeah, on notice issues, you're absolutely correct. Email suffices. Let me say this, you want best practices on TROs. Most TROs are denied, that's a fact. Many of them, or perhaps most, are denied for lack of irreparable harm. You know, the first question, I think the first question that pops into Judge Strobel's mind when she sees an ex parte is, how is the notice? Is the notice adequate? My first question is, why are you here? Is this really an emergency? Or should this be heard on noticed motion? So I would be very careful about your irreparable harm showing if you appear ex parte.
So I'm happy to say a little bit about best practices for notice. A declaration from an attorney that says, I caused timely notice to be given is not what we're looking for. I'm looking for a declaration from the person that gave notice, whether it's the lawyer, it's a paralegal, administrative assistant, and not just that I gave notice, but what did I do? I talked on the telephone to so-and-so, who I know is the CEO of the company, or I know is the lawyer for the defendant, and I said, I'm coming to Department 82 on X date at 8:30, asking for this relief. That's what the declaration should say on notice. Who did you talk to? Or who did you send an email to? How do you know that they're the right person? And what did you say? What did you tell them? On irreparable harm, of course, I agree with Judge Chalfant that is very essential showing. And I'm looking for evidence. An attorney's declaration on irreparable harm to the client is rarely competent. You really need the company or the individual client to say, I will suffer harm because of X. It's not just my client will suffer harm, but I'm the one who's suffering the harm, and explain what that harm is that would be suffered if the TRO were granted.
Okay. In that instance, I think I know the answer to my next question. What are your thoughts on ex partes with no notice? Is that something that is ever in the cards?
Rarely. I like to say you literally have to have solid evidence that the defendant has plane tickets for a non-extraditable country in order to come in without notice. You got to make a compelling showing why notice should not be given, and it is rarely good enough.
I completely agree. You really have to have a tremendous showing to give no notice, and a concern or a fear that something might happen if you give notice is not going to be enough. I certainly can empathize with that and understand the feeling behind that, but that's not usually competent evidence that in fact something terrible and irreparable will occur if you don't give notice.
I think we're all three pretty consistent on the no notice ex parte.
Okay. Another issue that comes up, I know the code provides that TROs can be sought based on a verified complaint. The general practice is that that's not what the courts like to see, and that actual declarations with competent evidence generally going to be required. Do you have any thoughts on the verified complaint avenue?
I think, oh, sorry, go ahead, Judge Chalfant.
Go ahead, Mitch.
Go ahead.
So yeah, I have many pet peeves. This is one of them. There is appellate case law that says a verified complaint is evidence or can be evidence. Here's the problem. Well, two problems. One, a complaint is pled as ultimate facts. That's what a complaint is, not evidentiary facts. Therefore, I'll look at the complaint if it's verified, and I will frequently say, these are conclusions. This isn't evidence, and I won't consider it. In addition, if you look at Code of Civil Procedure 446, it says that a corporate officer or sometimes an attorney can verify a complaint, but when the corporate officer verifies the complaint, it's inadmissible as evidence. So complaints verified by a corporate officer are never going to be considered on an evidentiary basis. By far the best practice, even if you have a verified complaint, is to present evidence by way of declaration and authenticated exhibits that has a foundation of evidentiary nature. And one thing that really a sub-pet peeve, I often get declarations from parties who say, I spoke to the bank, or I spoke to defendant corporate entity X, and they told me. Well, that's just not good enough. You spoke to a human being. If you don't remember the name of the human being, then lay a foundation in that regard. You talk to somebody in their foreclosure office or wherever, you don't remember the name, but that person said, don't tell me you talked to an entity. That is just totally lacking in foundation.
I was just going to say that it's interesting to me how often people rely on a verified complaint, and often the allegations are stated, the important allegations are stated on information and belief. And, going to what Judge Chalfant just said, it's, you have to have evidence, or what Judge Strobel said, you have to have evidence. And it's, when you talk about best practices and issues with TROs, I'm always surprised at what evidence you have or don't have, and the evidentiary showing that's made to get the relief. Sometimes it's woefully inadequate.
Final thing I'll say, I agree with what both Judge Chalfant and Judge Beckloff said. Sometimes when people are relying on a verified complaint and I go to the verification itself shows that it's not competent. It says, to the best of my knowledge, or I believe this to be true. So if that's what your verification is, I'm not really treating it as though those are evidentiary facts.
One other thing I might add is if you have attachments to that verified complaint, like a contract, you might want to make sure that the contract is legible, right? When it's copied and then e-filed, because it's not unusual to have a contract, maybe on a writ of possession, that you can't read, that's illegible, even in the courtesy copy. So it's important to know what the court can make of the evidence you do provide.
Okay, I appreciate that insight. Why don't we switch gears a little bit and turn to writs of attachment. I know that some of these issues are going to be similar, but I also know there's some specific questions that many of our members had. We understand the clerk's office just reopened yesterday, and we received several questions regarding the status of writ issuance. Are you aware of, or do you anticipate that there's going to be a delay in issuance of writs at this point, just if nothing else because of the backlog from 3 months of court closure?
Okay, so I had my clerk contact the writs clerk and ask about the current status, and this is what I was told. And interestingly, if you make your notice of motion or application, memorandum of points of authorities, proposed order, and submit the writ all at the same time on a notice basis, then that gets filed directly in our courts, either one of the writs courts, and assuming that the application is granted, the clerk will print out, the clerk's office will print out the writ and apply a wet file stamp and mail the writ to the lawyer, the moving party lawyer. If, on the other hand, you do not include the proposed writ with all your moving papers and it's granted, then you will e-file the proposed writ to the clerk's office after the order has been granted, and the writ will be routed to you electronically by the writ clerk. Therefore, it is in your interest to do the latter. That is, don't include the writ with your moving papers, because otherwise it goes through the wet stamp process. And if you'll get an electronic writ faster, if you wait until the application's been granted, submit your writ electronically to the clerk or ask it to be issued, and then it gets issued electronically. Now from there to the sheriff, taking the writ to the sheriff, you're on your own. The clerk has nothing to do with that. You got to go to the sheriff with your writ, whether it's electronic or wet stamped. So is there a backlog? I didn't ask that question, so I don't know the answer to that. But you are better off trying to do it electronically.
And I might add that the clerk's office is really not opened. It's gone virtual. So there's no clerk's office to go to. People are teleworking and have been teleworking during this 90-day period. So your first dealing with the clerk's office will be through the website. If you can't get done what you need to do through the website, which has been enhanced, then there's a call center. And if the call center can't help you, then you can make an appointment to come in and deal with the clerk's office. So that's part of the new normal as well.
Just to add to that, for example, the filing window is not physically reopened in the Moss Courthouse. So you should continue to use the drop boxes outside the courthouse.
Okay. And just to follow up to that, I know that the Judicial Council has emergency rules related to unlawful detainer writs of possession. Our understanding is that that doesn't affect any other writs of possession or writs of attachment, for example. Are we correct in that understanding?
maybe beyond our range of knowledge, but I guess I think you would be right. You're going to get your vehicle back probably on a timely basis. I would think so, but I really don't know.
Okay, and I know we talked about verified complaints in the context of TROs. I know that's available. In this context, I'm assuming there's no reason that any of you believe that a verified complaint would work with regard to attachments. Is that correct?
Well, I would 2 years ago I would have said that's correct, but there is appellate case law that, and the reason is that the injunction statute expressly says that you can use a verified complaint. The attachment statute, I don't believe does, but and I know the writ of possession statute does not. But there's appellate case law that says a verified complaint can be considered as evidence, whether the statute says so or not. So you may be able to do it. I wouldn't do it. You may be able to, but as long as you're on writs of possession and writs of attachment, let me address one issue, which is that at least I require a memorandum of points and authorities for both. I've had a number of applications for writ of possession where they did not submit a memorandum of points and authorities, and I rejected it. And I think it is commonly understood that at least my practice is to require points and authorities in both applications for writs of attachment and writs of possession.
I agree.
I make 3.
Are there any other, we'll call them pet peeves that any of you have with regard to writs of attachment or writs of possession that you see frequently repeated that you prefer not to see in your courtrooms?
Well, Judge Beckloff mentioned the minuscule print that is often in a vehicle case, the contract. We have to be able to read the contract, and related to that, sometimes the plaintiff is the assignee of the contracting party, and yet they don't provide the assignment. And I deny those writs of possession as the wrong party. So you have to prove to me, if you're an assignee, that you are in fact an assignee. Now, often the contract has a box that they check and they name the assignee. If you can point that out to me, great. Otherwise, I need a separate, assignment contract that shows the assignee is the proper plaintiff.
On that issue, if the party seeking the writ of possession is the assignee, I also question whether you have competently proven business records. Often I'll get a declaration from someone who works for the assignee who is purporting to lay a business records exception for documents that aren't his company's documents. And so either you have to have someone from that company who lays the foundation, or you need to show that in fact the person who owed the money actually paid me, assignee, after the assignment, which then kind of admits the debt. Otherwise, if you're probably not competent to establish someone else's business records.
And I know we do see that very strictly enforced in each of your courtrooms. I know in other instances, seems to be a little more leeway, but I think our experience has been that in your courtrooms that there does need to be a complete foundation laid for each of those, especially on the business records exception declarations. And so it's good for us to know that that's really what's being demanded of our membership. Let me switch gears again and get to receiverships. I know there's a lot of anticipation going forward. One of the things that, a question that's come up is with regard to assignment of rents receivers. There's an expectation that given the climate of the economy, that there may be more need for appointments of these types of receivers going forward. As far as your calendars are concerned, do you anticipate that these are things that can go forward on an ex parte basis first of all, and get heard relatively soon? And secondly, is that something that would normally be granted on an ex parte basis? For example, you have an apartment building and you need to get in there and collect rents, and there's going to be an issue with timeliness. Could you address those two questions?
Sure.
Oh, go ahead.
Receiverships are, it's a harsh remedy, hard to get, on an ex parte basis, rarely granted for anything except assignment of rents. And there's plenty of case law that says, look, you're cheating when you're collecting the rent and not paying your mortgage. And so, rents and profits receiverships on an ex parte basis with an assignment of rents clause in the deed of trust. Absolutely, I grant those on an ex parte basis. But a mismanagement receivership, you're stealing the money and we're partners and I want to receive it. Those, I've never, I don't want to be categorical, but I've never seen a mismanagement application that I granted on an ex parte basis. That requires real evidence of mismanagement on a notice motion.
And going to the evidentiary showing, I often think that those mismanagement receivership applications ex parte are just not sufficient. They just don't have sufficient evidence to support that. I agree with Judge Chalfant on the rents and profits receiver, but in terms of this mismanagement, it's just it seems to me that they're very early brought with insufficient evidence, with a remedy that is draconian by the case law.
And in terms of timing, if you are granting those on an ex parte basis, do you anticipate that parties can get into court on a next day basis or 2 days? Do you have any idea of how quickly anyone will be able to get in on those ex partes?
Every day. Ex partes are heard every day. That's what they are. That's why, it's line jumping. And so you have to have a good reason to line jump. But if you do have a good reason to line jump, every day we hear ex partes, and that includes ex partes for a receivership appointment.
And there's no concern about, for example, reaching capacity on any given day? Well, if the court has, say, 20 ex partes, is that something that can be accommodated?
Well, let's hope we don't have 20 ex partes. Actually, I think the most I've ever had on a single day was 10, which was hard to do. But I'm not anticipating overwhelming number of ex partes. Maybe I'm being naive there. I don't know. But we'll have to find out next week.
Oh, one thing I would add to that is if you're bringing an ex parte, which is rich with evidence, you have the stack that is 3 inches high and you've got multiple declarations, and I have other ex partes on my calendar that morning, it wouldn't be unusual for me to say, okay, really, what's happening before tomorrow? If something really isn't happening before tomorrow, first I want the defendant to have adequate time to brief this and for me to read the papers, and I may not be able to do it that day, in which case I might continue it for a day or two or a week. I wouldn't put you out necessarily if you have an emergency. I'm not going to put you out past the emergency, but I'm maybe asking you that question, really, if nothing's happening until Thursday and I've got 20 ex partes on Monday, I might put you in on Wednesday.
And in terms of best practices, I might suggest that you think about, I don't want to call it an executive summary, but some roadmap that takes you through the evidence that is essential to your ex parte request, that is concise. So, it is a pretty daunting task to sit down and be faced with 8 inches of paper, right? So to the extent that the attorney can give you a roadmap or an executive summary to say, here is section 4.3 of the deed of trust, and here's what it says, and here's, exhibit A is the deed of trust, exhibit B is the contract, here's the contractual provision, I mean, that's always helpful to help us, help us help you, help us navigate those papers to get them processed so we can address the issue on the merits.
Okay.
And Gary, one other thing, sorry to interrupt you. In terms of, will it be too much if we have a lot of ex parties? Well, the ex parties are all going to be, you're appearing electronically or remotely. So it's not about, all of these people show up and we have a social distancing problem in the courtroom. It's really about each judicial officer sort of managing his or her work for that day and how best to do that. And Judge Strobel said, I may figure out what the last day is before you really need that order and have you come back on that day. I've certainly done that. So it's really not about the people so much as it is about management of the workload.
An interesting issue on I'm sorry.
I'm sorry, may I add just one other issue? This is on attachments and possessions. And I kind of wanted to jump in, but we got off on receivership. So, they're on a short turnaround in terms of the briefing, and we have e-filing, and I know, and you're well within your rights to file that document that's due on, whatever day at 11:59 that day, PM, and it's deemed filed that day. But realize when you e-file, it doesn't populate to my file. So even though I'm an early bird and get here early, it's not going to be in my file until someone comes to work at 8 o'clock and scans that document and puts it in my file. So, to me, you can get it filed at 11:59 PM, but it really gives your document short shrift in terms of the amount of time I actually have to work with it before the hearing. So on attachments and possessions, I am always sort of shaking my head because I'm always waiting for the papers, and the hearing's coming and they got filed and then they finally got populated to my electronic file. But the earlier you file it, the earlier we see it. If you file it before 4:30, for example, it's going to probably populate to our file that day. After that, it's going to be sometime mid-morning or late morning the next day. And it's just unfortunate when, at least for me, speaking for myself, when I feel like I have little time with the papers.
On ex parties, an interesting issue that I don't really know the answer to concerns courtesy copies. The general order before the pandemic said that courtesy copies are required of, I don't know, any memorandum over a certain length. But now how do you get your courtesy copy to us on an ex parte? Well, it's not going to be easy. That we have a Dropbox for papers, and maybe if you give a courtesy copy to the Dropbox, it will filter its way up here. I've asked my clerk on ex partes if I don't have a courtesy copy to print it out for me, unless it's a very short, simple one. But I have found, particularly trying to work from a Surface Pro, a 200-page declaration with attachments, I just cannot look at on the computer. I need a hard copy of that. So, I'm not sure what the answer is, Dropbox, but I know you can't just, at least I don't think you can walk up to Department 85 and drop off your courtesy copy. Maybe you can next week. I don't know. That's something I don't know the answer to.
But it would still be the preference of all of you to receive courtesy copies. Is that right?
Certainly me.
That's me as well. I fit into that. But I just go back to my point earlier. 11:59 PM is great for you, but it's not so great for the court. And I stress that because I feel like everything is filed last minute. And I get that, but it just cuts it short on my end.
Well, have been working from just electronic copies of everything. I'm getting a little bit more used to it, but certainly lengthy declarations, evidence, etc. It's difficult without a courtesy copy.
All right, we'll definitely keep that in mind. One specific question we had on receiverships was because of the lack of access to the courts, it's been difficult for receivers, for example, to get instructions or authorization from the court. Obviously not everything rose to the level of an ex parte matter. do you have a sense as to how quickly receivers may now be able to get in to get instructions, whether, the fact that they weren't able to for 90 days, is that going to be a consideration in terms of whether something justifies an ex parte request?
Well, I'll just say everybody has been in the same boat, not just receivers. We've been basically shut down except for ex partes. So from my perspective, I will try to accommodate as quickly as I can on my calendar, but there's a lot of different priorities besides receivers who need guidance. And on that point, I want to just mention one thing, which is not infrequently, I have motions from receivers to approve something that the order I signed appointing the receiver already says they can do. I won't rule on those. I look at that order very carefully about what needs to come back for my approval and what doesn't. And if I've said, you can hire a real estate appraiser or you can hire consultants, don't then come back to court and say, bless this consultant at this amount of money. Maybe I don't know if Judge Chalfant and Judge Beckloff see that differently, but if that's the kind of direction, if you've already got it in your order, you should go with your order and do it in an appropriate way.
There's an exception to every rule, and the exception to the, my experience is the exception to the irreparable injury requirements for ex partes is receivers. They just roll in ex parte whenever they want instructions without any showing of irreparable harm. And frankly, they work for me, so I allow those ex partes unless they're opposed substantively, in which case I require a notice motion. But so the answer to your question, Gary, is, a lot of the time they come in ex parte, which means they're getting heard on an immediate basis. So I don't know if you have any receivers in your audience, but I don't normally require them to make a notice motion and wait 90 days for something unless somebody is opposing them substantively and wants to brief it.
Okay, that is good to know, and I'm guessing that there are some receivers in this audience today. I know our time is running short, and we've covered some of the prejudgment issues that people are concerned about. I wanted to just quickly touch on a post-judgment issue. I know it was mentioned earlier that Department 44 is no longer handling post-judgment matters. We understand that for the most part, they're going to be sent to the individual calendar judges who initially handled the matters. I think Judge Chalfant, you mentioned earlier that post-judgment receiverships are also going to the IC judges. Is there something you can speak to as far as the expectations of what that's going to look like? Will the IC departments now be overburdened with what used to be exclusively a Department 44 issue? Or is that something that just, because it's going to be spread across so many different courtrooms, that it should be absorbed fairly easily?
I'm not sure we can speak to that. I can tell you that the IC judges are being offered a class in how to handle post-judgment matters. Some of them have handled them in the past. Some of them they never have handled. I don't know what kind of burden it's going to be on them. I think they are concerned about the burden, but nobody really knows.
I see that we're running out of time. Unfortunately, we had a lot of questions, and maybe I can, in the future, talk you into another session to address the remedies section. We do have a lot of questions that were follow-ups that I think may be answered just going forward once the court reopens and we'll get to see the new lay of the land. So I'm hoping that that's the case. I see we just have about a minute left. Before we wrap up, I did want to thank each of you, Judge Beckloff, Judge Chalfant, and Judge Strobel, for your willingness to participate in this program. We we in the Remedies section and at the LA County Bar all appreciate your participation. Just very quickly, I wanted to thank Judge Samantha Jessner for helping arrange this, Ron Grote, Stan Dissy, and Fatima Jones at the LA County Bar. We thank you for your attendance, everyone. We hope that we've answered a good number of your questions. I apologize for not being able to get to every question, but it's our unusual times, and hopefully we've helped everyone out along the way. Again, thank you all for attending. Be well and stay safe.
Thank you.
Thank you. Thank you.